When a family law attorney is preparing a client, when I prepare a client for a trial, what are we discussing? First of all, we're discussing the demeanor, what to expect in court, procedures, tactics, cross-examination questions, direct examination questions. We go through all of the exhibits to make sure we didn't miss exhibits. And this meeting can last between 2 to 6 hours, depending on the quality of testimony I hear the witness has to offer. For example, we go through direct examination questions. When I ask a question and a witness starts rumbling, not answering directly the question, if it's a simple yes or no question, starts to tell me a story that I didn't ask to tell me, that's where coaching or explaining how to answer a question comes in. For example, easy question, how old are you? And the witness starts to say, well, I think I am. It's like, no, just tell your age. And where have you been on this date? And the witness starts to say, well, I don't remember. And if that happens, I already have ready exhibit to show, okay, well, would it help to see your phone log, your calendar? Will it refresh your recollection? Because sometimes witnesses are allowed not to remember. We all don't remember sometimes what we ate yesterday. So in these type of cases, we have exhibits that we enter into evidence. So first we mark as a lawyer, and then we admit it. That means the judge can consider this exhibit as entered into evidence. And those exhibits need to be authenticated. What it means is that they cannot be hearsay documents. They have to be documents prepared either by the client, or if it was admission by the party opponent, an exception to hearsay, if the other side wrote an email to the client. Photographs, declarations, anything that a client prepared. Then there are exhibits such as for recollection of memory, emails from other people other than the opposing party, from doctors, from child therapists. Those documents are considered hearsay, but it helps the witness to remember what happened on a specific day, what led to a specific incident. For example, if witness didn't show up to a visitation and the other side is claiming contempt, then a doctor's note will refresh the recollection for the witness to remember that, actually they were in an accident that day. So that's the direct examination. Then cross-examination. Cross-examination consist of more leading questions, and cross-examination is an extension of challenging direct examination. So cross-examination cannot talk about topics that were not covered in direct examination. So if in direct examination we're talking about visitation, then in cross-examination we cannot talk about child support. And in cross-examination, the questioning starts with, isn't it true that you said X, but in reality it's not X? And here's the exhibit to impeach your testimony that you gave prior. What is impeachment evidence? Impeachment evidence is not evidence that was submitted originally. Impeachment evidence is aha moment. Aha moment is something that usually opposing counsel is hiding to say, I got you. So here you are. You didn't tell the truth this time, and therefore I have this document to prove that you lied under penalty of perjury. That's called impeachment, either document or it could be an impeachment witness. I created this book to help you understand the divorce process without getting lost or without getting a heart attack. You can buy it on Amazon in all formats, including audio format. And so when we meet at the office, we go through all of the potential situations that come up. And this would be the time for the witness to tell, well, here's what could happen. I think he might have this document, he might have this video or she, and we have to be ready for that. When I prepare the witness, I say, first of all, when the question is asked, before answering it, wait 3 seconds. It sounds a lot. 3 seconds sounds a lot, but it's not. Because it gives me an opportunity to object if a question was objectionable. For example, hearsay question, calls for speculation, or irrelevant, or misstates witness testimony. It gives an opportunity to give a clue to think about the question if the question was defective, and it gives the judge an opportunity to sustain or overrule the objection. If objection has been sustained, then the witness does not need to answer the question. If the objection was overruled, then the witness noticed what there is some problems with the question, still has to answer the question to the best of his or her ability. So then we go through the procedures. How is trial going to work? Who is going to testify first? First, the case in chief. Whoever puts the case first, that lawyer will put their witnesses first. For example, if someone is asking for child support modification, they will put their witnesses, their party, client, and then our side, our client. For direct examination, and I will be cross-examining both if they put my client as a witness for direct examination. Then we have an opening statement. We have direct, cross, redirect, potentially recross, and then closing statement. And then we ask the court to enter a statement of decision before the matter is submitted. And then the court at the end, when the matter is submitted, meaning when all witnesses, case in chief, everything is submitted, then the court is allowed to make a decision. That's the time. And the court has a couple options. The court can make a decision on the fly and say, here's my decision, write it down, or I take it under submission and the court will issue a decision within 3 months. Usually it's much sooner. So this is a quick overview how trial procedure works and how I prepare my clients for the trial. I hope that was helpful. See you soon. Bye.